and looking at data protection, and they're realizing that, okay, there's a need for us to take this seriously. I mean, you could be fined. It's a lot of money. We see it a lot of times in the news. Just regulators finding companies huge amounts of money, and I mean, just navigating how to go about that. There's also the reputational risks that come with it. You don't want your brand to be associated with, oh, they suffer a lot of privacy breaches, oh, they're in the news all the time, like the court, just all of that mess is something you want to avoid. I mean, if you are not the Metas, the Google, the Amazon, I mean, they're in the news a lot for these things, but then I think maybe there's still that goodwill that keeps them going, that kind of just makes sure that companies continue to patronize them. But then if you are much smaller in the game, a little breach here and there can just put your brand or your reputation at risk. Investors might not want to work with you. Like, just when you look at all of that, I mean, it gets messy. So that's something that um, we look at when we say privacy and data protection is becoming important. Just that trust also, you want to build it with customers. You want to build it not just with the organizations that you might be handling their personal data. You also want to build that trust with individuals that you might be coming across their personal information. So that's something that can be looked at. Then also every business is a data business now. Like, every business is literally collecting, I mean, a lot of personal information. So, I mean, because you are collecting personal information, you need to make sure that you have measures in place to protect that information that you are collecting. So, yeah.
Wow, thank you very much, Sandra. From your explanation, it seems like data is new gold, so everyone should practically
Yes.
be looking at this right now. Okay, thank you. Moving on to Anita, what do you think are like the major global privacy laws that professionals need to know? Because this webinar is for lawyers, so what do they already know, and what else should they be knowing, in this space?
Okay, we're going to start with the model law, which every law is made and is like more of like channeled or created after, and that would be the section regulation. So it's the GDPR that is a model law, and everybody should know that. I think everybody knows that, but again, let me know as you that everybody knows that that's the model law. But if we're going to trace back to when data protection actually became a thing, but I'll not say it's obtuse, you're also going to be looking at, okay, let's see the European Convention on Human Rights and the Charter on Human Rights about data protection itself and privacy. You're looking at the GDPR, and you're also going to look at the E directive. Now, the E directive is, or the e-privacy directive, if you want to call it, it deals with something called cookies. Now, I'll tell you a very funny story about cookies, because cookies is something that I had no idea existed until 2 years ago. And then I went into a rabbit hole of it. It's this small text that, people find this very funny, that they visit a site and next thing they know is like they are getting marketing advertisements on something that they glanced through, they didn't even look at, or maybe they just maybe passed the website and then they keep seeing this marketing ads over and over again. That's just a result of cookies being like imputed on your phone, your devices. Anytime you visit a website, you see this accept cookies, and of course, we all accept all. So the e-privacy directive is another legal legislation issue. You're looking at the CPPA and the CPRA, the Californian, I think it's Consumer Protection Act, and the Californian Consumer Protection Right Regulation, something like that. So you're looking at the CCPA and the CPRA. And for the EU, there are different countries have different data protection acts. Estonia has theirs, Germany has theirs. If you're in Nigeria, you're looking at the NDPA, obviously, and the NDPR. But the thing is, there's so many laws. So let's not try to get you really, really scared about the number of legislations, because all of them were modeled and created and crafted to look like the GDPR, with just little and little changes here and there. Like for the CPPR and CPRA, there's this do not sell my data. So you don't sell their data. So you have to like ensure that you have that in your privacy policy or in your cookie policy that do not sell my data. For the EU, you don't really have that. Nigeria is modeled after the GDPR. So what is attainable in the GDPR is attainable in the NDPA. So these are the laws. These are the major laws. But once you know the GDPR, it's 84 pages long and a lot of recitals. I think you're that's a great start. And then every other thing can come out.
Okay, thank you. Thank you for that very detailed answer. But just as a follow-up, as a Nigerian lawyer who is hearing about this for the first time, we did like a first poll and we were just checking like people on this webinar, what knowledge they have. Do they know anything about, privacy or not? And over 34% are sort of just hearing about it for the first time. So in your opinion, Anita, do you think that as a Nigerian lawyer, do they already have the foundational prerequisites to get into the field of privacy?
Yes, you do. Yes, you do. Don't think it's tech related. As I said, and of course, in my bio, you could see that I did litigation. Litigation, and Nigeria helps you to not specialize in one thing, so you're not really streamlined. You get to do everything. What actually got my interest to it is that we had a case that had to do with MTN and the spectrums. And that's when we came into the whole rabbit hole. I'll call it a rabbit hole of data protection. And my interest was piqued from then. I was like, okay, what is happening? Because it's so easy when you go online and post your data. Now, from an individual perspective, it's easy for just, okay, it's Facebook, you're sharing stuff. You don't know what Facebook is using your data for. So you have the foundation, really, as a lawyer. That's the first thing. You have the foundation because you already have that ability to read legal legislations and understand them. It's basically as you're reading the Constitution or you're reading your ACTA or whatever law is there. So as long as you can just see, you read it and then you implement. And then there are also case laws. You see what the court has actually decided because the CJEU, the Court of Justice of the European Union, has a plethora of cases on data protection. One I would actually want everybody to read, which is very interesting, is the Max Schrems case. I would have to write that down. It's the Max Schrems case. That would just open your eyes. There's on Privacy Shield and then Safe Harbor. It's a huge chunk, but I think that would just pique your interest on what data protection is and how it works. So I suggest you read the Max Schrems case. That would help you more.
Okay, thank you so much, Anita. That's exactly what I wanted to be sure of. If Nigerian lawyers who do not have any idea or experience or whatever in this space already have the foundation, and the answer to this is yes. Awesome. Moving on to Sandra. So we've got some questions and answers from the legal lawyer perspective side of it. Let's look at businesses. What do you think? Why should businesses take their data protection seriously in Nigeria today?
That's it. That's a good question. One, like Anita mentioned, we have the laws. Um, before 2019, we didn't have anything that was talking about privacy or data protection specifically. Save for, there's the constitutional provision. Then we had the NDPR, we had the implementation framework, and then in 2023, we have the Act. It's important because we find out that Nigerian companies or Nigerians are increasingly going into businesses that collect a lot of personal information. We're looking at fintechs, like there are a lot of apps, fintechs, edutechs, just health techs, a lot of that. We're seeing startups coming up in that area now. So many companies just collecting a lot of data. So businesses need to take it seriously because now laws are in place. There was the NDPR, and then people were saying, "Oh, we have just a regulation. We need an act. We need something." And then now we have an act which provides more stricter fines. So this is something that businesses need to take seriously because now laws are in place. Laws are in place. There's the accountability part of it. We have the commission now in place who handles all of these enforcement matters. So businesses should take it seriously because fines are strict now. There's a law in place, so we cannot claim ignorance anymore. Also, Nigerians are becoming aware. I think that's also something that I would like to bring up. Not just lawyers now, everyday Nigerians are becoming more aware because we can see things like this on Twitter. I think there was, I can't remember what year it was. I think it was in relation to the NBA, for example. I think people were getting texts on their phones, or vote for this person, like just adverts on who to vote for, what candidate to vote for, and it was all over Twitter. People were like, how can the NBA and how did people how did these contestants get our information? Why are they sending us these messages? So increasingly, you see that on places like Twitter, Instagram, Nigerians are becoming more aware of, okay, there's a need to protect this information. There's a need for my information to be protected. I actually have this right to privacy. So I think that's also from that the standpoint of awareness. And I think we should just realize that when Nigerians become aware of something, I mean, they always hold on to that thing, like they want to pursue it to the latter. So all like areas like that is where businesses need to sit up and start taking privacy and data protection seriously.
Wow, thank you so much, Sandra. So basically, from the introductions, we've already covered what privacy is, what it would be for Nigerian lawyers if they already have like the foundational knowledge, and if at all there is even a need for it, you know. And from Sandra's answer just now, we can see that definitely yes, and it's a growing field. So the need for it is not just starting, but it would also continue to grow. So this brings us to the end of the part one of the webinar. So we'll be moving on to the second part, which is the work and tools of a privacy lawyer. So to kick off on this side, Sandra, as a follow-up question to your, last question that you just answered, what are the documents? So basically, as a litigation lawyer or a normal, a litigation lawyer in Nigeria, you need to know, of course, your civil litigation, your motions, all of that. In the privacy space, what are some of the documents or deliverables that a privacy lawyer need to produce?
Good question. First and foremost, I would just start off and say there are usually a lot of documents. I mean, it might just be on anything, right? It might be on a new project, it might be on a new process like the company is introducing, depending on how you work. I mean, if you work in-house, we're looking at first policies and notices. Policies and notices, you might need to develop a policy from scratch. You might need to review an existing policy to kind of like match maybe an existing process or a process that is being introduced. We're looking at notices as well. Privacy notice is something that, depending on what the process is or what the solution is, you might have to kind of like embed a notice into the system. So you might find yourself having to draft that a lot. One prominent one also is the data protection impact assessment and the privacy impact assessment, which kind of looked at different things. The privacy basically looks at reviewing a system for a process, a solution, making sure that it protects the rights of, I mean, those that you're going to be collecting their data. While the data protection impact assessment kind of just looks at high risk processing. If the processing that you're going to be embarking on, whatever that is going to kind of affect the rights of data subjects. So you find yourself doing that a lot because, I mean, there are situations where you also have to make judgment calls. I mean, this is an initiative before you. Does it need a privacy impact assessment, a full-blown privacy impact assessment, or does it need a data protection impact assessment? Or can we just look at this and, I mean, can we close this up in a way that we don't even have to go into this assessment? Because I bet you these assessments, they can take pages. I've seen assessments of 150 pages. I mean, just on, and there's something to add. You're adding controls into them, you're adding measures, technical measures, organizational measures, you're capturing solution interfaces. All of that goes into the document. So yeah, a privacy impact assessment, a data protection impact assessment is something that in privacy you find yourself doing a lot of. Also, an AI risk assessment. This is fairly new because I think that a lot of maybe 2 years ago, privacy departments were not really looking at AI assessments. or assessing the risk in AI systems or solutions that kind of like have an AI component. But we're looking at it today that a lot of companies are beginning to require their privacy departments to also be in charge of AI governance, and all of that. So it's something that you should be prepared for. Open your mind to it. Like, don't just look at privacy alone. Start looking at things like the cybersecurity aspect of it. Start looking at things like the AI component of it, because you might be fortunate. I would say I use the word fortunate to get into an organization, and I mean part of what the privacy team does is review systems for AI. So that's also something that I find myself doing, reviewing systems for AI, assessing the risks and all of that. Then also there is the data processing agreements and data sharing agreements. Data sharing agreements where you're going to, as a controller, you're basically sharing data, or should I say, as an organization, you're basically sharing data with another organization who is basically going to use the data to render services to you, or the data sharing agreement where it's between two controllers deciding how data sharing should work between each of them. So you might find yourself reviewing that a lot. Um, Depending on if your organization has a template, you might have to review that template to match what that particular initiative is looking at. Vendors are different. Companies work with a lot of vendors. So when you have a data protection agreement or a data sharing agreement, you have to look at it. You have to do like a line by line review of, does this apply to this vendor we're dealing with, this business we're dealing with, or does it not apply? You are looking at things like including clauses into them that would match what the business is about. Also, aspects that would require you to protect personal information, like confidentiality clauses, which all of your lawyer skills, they really come into play. It's why this field is, it's kind of not a perfect fit from something that I mean lawyers can do, because you're already reviewing agreements, you're already reviewing contracts. So I mean it's something that kind of like just really marries with what the legal profession is about. Yeah.
Thank you so much, Sandra. I was going to ask a follow up. Like, I mean, all of these things you're mentioning, can lawyers do it? But then you already,
No,
proactively read
absolutely,
the mind.
absolutely,
And
absolutely.
then,
There's like we're already doing it. We're already doing,
yeah,
and you need all of that analytical thinking,
yeah.
logical thinking, just being able to like the fine lines, details, and all of that. Like you already kind of have those skills. So
Okay, awesome, awesome.
yeah.
Thank you so much for that very detailed answer. From all of what you've said, I can gather that as legal professionals, we have the basis. All we need to do is just grow from the basis that we have and learn, like, the new things as additions. But let's also hear from Anita from a practical perspective. Anita, what kind of daily task do you handle as a privacy specialist at Coolbet, especially when you're managing things like DSARs and third-party due diligence?
She has said everything. Sandra has said everything. Because I'm going to just talk about what I
Yeah.
want, because the EU AI Act is still in its transitional phase. It's going to come into full force in August 2026. And something I just did just this week, which has been a back and forth. As Sandra said, privacy professionals didn't really look at AI. As of the time, we just deal with our DPIAs, PIAs, vendors assessment for third-party vendors. You're looking at your ROPA, that's your record of processing activities, to ensure that you have recorded every processing activity as an organization that you have. So basically, the record of processing activities, for instance, if you're in an organization and you collect your employee data to pay their salary, their bank account details, and their full name, you have to record that. So that's one of the things I do. I keep the ROPA. Slack just recently added its AI feature. And then I had to conduct a PIA for that. Now, you can also determine, okay, is he high risk or not? Well, it's not high risk based on the definition in GDPR, which says systematic monitoring, if it's going to significantly affect the rights and the fundamental rights of data subjects and all of that. But we had to conduct a PIA just to have it on record that, look, we have conducted this because of it's an AI tool or an AI feature. So I just conducted a PIA and then crafted a PIA template, like an intake form where we answer questions. Okay, Are we providers or deployers? Basically, providers means we are the people making and developing the AIs. Deployer is you're the user of the AI. Obviously, we are the user of the AI in Coolbet. So you're looking at ChatGPT, you're looking at Gemini. These are all the things you need to conduct a PIA for, not a DPIA, just a PIA to ensure that you have looked at the risk of using these AI tools. And for me, conducting for Slack was a lot because the questions you need to answer is based on the fact that are you the providers of this AI? And I'm like, okay, I'm only a user. So I had to start digging deep, getting information as to, they were asking us what's the training model. And I'm like, I don't know. I didn't train the AI. What data sets did you use to train it? I don't know. But for the AI Act, for a deployer, or let me just use the word user, right? You just have to show, you have the responsibility to be transparent that, look, this tool you're using, like Slack, for instance, has AI feature in it. So if you're asking the AI to streamline or search a particular thread on Slack, you're talking to an AI, not talking to a human being. You're talking to ChatGPT. ChatGPT and Gemini are not your friend. They are AI. You're not talking to a human being. So it's our duty to let people know that as a user, like, look, or for instance, let me use a very, 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 I think something that's practical and everybody can relate to, chatbots. When you open your EcoBank app or whatever app and you see Zaki or the UBA Leo, that pisses me off every time. So when you open that app and you see Leo, Leo is not a human being. Leo is a chatbot. Now, UBA or Zaki from EcoBank has the responsibility to tell you as a user that you are chatting with a chatbot. So from a user's perspective, EcoBank is supposed to conduct a PIA. Is this going to affect the rights of the individuals interfacing with the chatbots, right? AI is happening. What are they using? Because AI is a couple of data sets, right? What are you using to train these AI models? Because it's data sets, a lot of people data, because you can imagine you can ask AI about something because you are feeding AI your details when you're asking AI, oh, I have this, and that, and that. Can you tell me this and that and that? You're feeding that AI with details about you. So it's going to come up and answer questions based on the profiling it has done of you. I mean, to other people, it's helping me do my work, but is this ethical? So we're talking about ethical issues that may arise too as well. So, but for Slack, it was just something to help you search and summarize. So it's like pretty low risk. If you're looking at Gemini, so these are the things I do every day, PIA, and then I have to fight vendors because from Coolbet, we have a lot of vendors. We're talking about payment providers and we need to have do a vendor's due diligence where we send them a template and they have to fill out. We need to, so the template for doing the vendor's due diligence is to see their privacy and information security program at their company because we are sharing our customer data with them. We need to do our due diligence as controllers, basically the people that determine the purpose of using that data and the means of using that data. So we're telling them, okay, look, here's my customer data, here is their full name and their account details. So you need to process this data to do paying and payouts. But I can't just give you my customer's data because I have a duty as a controller without checking if you have the full security guard to ensure that somebody in the dark web is not trying to steal my customer's data from you. Do you have your full privacy guard? Like, do you have policies to say that not the secretary or the person from the front desk will just walk into the InfoSec office or the IT office and then have access to that data? So these are the things we check. You need to answer us and then we assess this and say, okay, this person has a weak data privacy policy in there or privacy compliance program in their office. They will have a strong information security program in their office. So we look at this and we check. On a daily or weekly, I do like 2 to 3. But the good thing is, before I joined Coolbet, this was something that we did in-house. And when I came, I'm like, oh, hell no, I'm not going to do this because we're talking about 400, 500, 600 vendors. And when you see those vendors, we're just like 3 of us in our team. We can't fill out this form or this assessment form by ourselves. So what we did was, when I joined Coolbet, I think that was my first task, was I curated the template that we would send out and have the vendors themselves fill it out. So I just made work easier for all of us. And it was really nice. So those are the things you do. And as Sandra said, you're thinking analytical. What is this vendor offering to you? What is this AI tool? What impact will it have? We are building trust with customers. Can a customer trust us? Because here in the EU, data is gold. I mean, if you read most of it, I told them in the chat that you can Google Eurolex. That's the page for EU acts and legislation, EU laws and case laws. If you look at Eurolex, you see some very outrageous cases where people in Germany are just like, okay, this person processed my data and sent me marketing ad, I am suing. And they get damages for it, non-material damages. Because somebody can say, well, I got this marketing ad and it sent me distress. You don't want to be that company that will be paying damages because you cannot put your house together. So you need to ensure that your privacy laws, your compliance, your procedures are intact, but not as just you as a company, but the companies you deal with. You have to do your due diligence as well.
Wow.
Yeah.
Wow. Thank you so much, Anita. That was very, very detailed. Before we move on to the next segment, there's one question in the chat that I think we can already answer now. So the question is, do you have to be a lawyer to work in data privacy role? Sandra, maybe you want to take this one.
No, no. You do not have to be a lawyer. A lot of people from IT are working in data privacy, have transitioned to data privacy. Someone from human resources has transitioned into data privacy. Anita mentioned that she was doing litigation for 6 years. Well, I mean, Anita is still a lawyer, so maybe Anita is not the best use case for this. But no, like you don't have to be a lawyer to get into privacy or data protection. I mean, you just need you need the soft skills. I mean, the
Yeah.
grit, the courage. You need the technical skills. Just all of that, which somebody from IT clearly already even has. Knows the security part of things. Someone who studied computer science probably has all of that knowledge of the of technical how to explain technical terms or have knowledge of all of those technical terms that someone in traditional privacy might not even be aware of. So no, you don't have to be a lawyer. So if you are looking at getting into privacy or data protection, however the case may be, you don't need a law background to get in there. Go through LinkedIn, go through people's profiles. You see a lot of people who do not even have law background in privacy, like doing awesome things in privacy.
Thank you very much. That brings us to the end of part two. And just as a follow-up in part three to this question that was asked, um, let's look at the tool. So, what is a specific privacy tool that could be useful when working in as a data professional or as a privacy specialist? So, I would give this question to Anita to answer.
Okay, so there are several privacy tools out there that makes your life easy. But let's start with the traditional ones. Spreadsheets. Lots and lots of spreadsheets. When I first joined Coolbet, everything was in spreadsheets. Our record of processing activity, spreadsheet. Our DPIAs, our assessment spreadsheets, everything was spreadsheet. That is because some privacy tools are, I mean, well, they're quite expensive because it's like subscription basis and licenses. But for me, the best one which we use is OneTrust. I'm pretty sure if you're in privacy already, you know the tool OneTrust. I'm just gonna brag a little bit. I'm a professional in that tool. It took me a year to learn it. It was, I mean, OneTrust is the best, I would say. You have Trustwork, you have Responsium, you have others. There are so many, but OneTrust is like a silo. You have to, like an onion, you have to peel and peel and peel and peel. So one second I was learning the data protection and data mapping aspect. Next time I was learning the DPIA aspect, and I was doing the training aspect. Now I'm in the cookie consent aspect. I absolutely hate that one because it's more technical than legal. Because that's where we have websites too that we manage, so we have to ensure that we are managing our cookies properly. So OneTrust, I would say yes. Spreadsheets is traditional. It makes it it's more manual, but you'll be able to trace if you can automate your spreadsheet, because right now we actually use spreadsheets for our DSARs, that's our data subject requests. It's automated, so we are able to track. So spreadsheet, if you're starting out, I would say start using spreadsheet. There are lots of templates and spreadsheets for every aspect of privacy law that you or privacy practices that you want to see online. Hallelujah to the internet is great. So you don't need to do things from scratch. You want to see how a DSAR should look like on a spreadsheet? Google, you see a template. You want to see how a DPIA on a spreadsheet should look like? Google. You want to see how a vendor's due diligence on a spreadsheet should look like? Google. Spreadsheets is where you start. Now, if you're working for an organization and you want to maybe suggest a tool for your organization, I would say OneTrust is a very good one. TrustWalk is also good. Responsium, great as well, because what we try to do in the privacy office for my organization is to ensure and centralize all our privacy program in one tool, right? So because the privacy program, we are talking about the legal part, but we have not talked about very important, very, very important, because it's actually a responsibility of controllers and organization is training and awareness to ensure that every employee in your organization is aware that privacy is the number one thing in your organization. That's why they have something like privacy by design and default in the GDPR. This simply means that before you start any processing, you have thought about privacy first. You're putting all the privacy rules first. So we try to centralize that. We were using OneTrust to send out training, but we overused it. So we had to use something like Know Before. Know Before is just a training application just to send out trainings that you can create or just get out trainings from. But I would say OneTrust is great. But starting as an individual and you want to start getting used to it, spreadsheets.
Okay. Thank you very, very much for that answer. Spreadsheet is readily available for everyone, so it's a good place to start. At least we already have where to start, the tool. Awesome. So moving on to Sandra, again, this is about becoming a specialist in this field. So what certifications or courses would you recommend a Nigerian lawyer who wants certifications would you advise that they look into?
So for certifications, there are a lot of them. I would suggest first those certifications and they have really comprehensive policies that you can go through to see. Oh, I hear so much about privacy notices. I hear so much about policies. I hear so much about this and that. What does it even look like? Like, what are the fine lines? Go to this, go online, check for these things. It's especially important because when you go through certifications, especially the initial ones that give you the foundational knowledge, the theoretical knowledge, you have to be curious because you have to be curious beyond the theory. It shouldn't just be, the GDPR says we should report breach within 72 hours, or for a processor, we need to, if we're going into a relationship with, if the controller is going into a relationship with the processor, we need a data processing agreement. Those are like the legal aspects of what these certifications would tell you, right? Which is fine, it's good that you know it. But as you go through the certifications, also go through them with curiosity. Be interested in, so if I were in an organization and this is going to play out, what does this look like? So theory is always there. The laws are always there. It's there for you to look through and say, oh, okay, this is what the law says about consent. This is what it says about lawful basis, or this is what it says about breach notification. But then when you are faced with an actual breach notification, the ball game is entirely different. It's not what the textbooks tell you, and every case is different. The breach that you're going to respond to today and address today is going to be very different from what you are going to work on tomorrow. But then when you look at the theoretical aspect of things or the legal aspect of things, it's the same across board. But then the practical aspect of, okay, what should I do? It's very different. And I also speak about this in relation to certifications, which I have them. Which is you mentioned earlier in the call, God's grace, the CIPP is the CIPP Europe, the CIPP Canada, the Asia, the just the host of CIPPs and the CIPMs that you have to do. But then when you get this, when you are kind of like working on getting this certification, they are really good. They are good in the sense that because when you look at a lot of job ads, it's there. The organization wants you to have, if nothing, that theoretical knowledge of, okay, she knows what privacy is in Canada. She knows what privacy is in Europe. She knows what privacy is in the US or in Asia, right? So they are really good because they put you out there. I mean, you when the ATS system, that's the applicant tracking system, when it goes through your resume or it goes through your CV, it's able to filter this person out. Basically able to shortlist you as a candidate to say, oh, this particular person has this certification that this job ad is looking for, and that's awesome. So I would say that in terms of certification, start with the foundational ones because the CIPPs and the M's and the likes, they are expensive. So if you cannot afford them, I think now they are running into what, 500 USD or so. So
550.
five, okay, thank you. So they're running into like, I mean, convert those. I kind of want to believe that most of the people on Discord are Nigerians. So convert that to Naira and you see how much that is, almost running into maybe a million or so. So you actually have to think, okay, if this is the end goal, where do I start from? So I personally did not get my CIPP Europe until 1 year after I was kind of like, should I say, in the thick of privacy work. So I had had the practical experience. So which is good, and not a lot of people are lucky enough to have that practical experience. So I'm not going to hold that against anyone. It was easy for me because when you are now having writing these certifications, you are writing the CIPP, it makes it easy. You're writing the CIPM. Like you can kind of like just see, oh, I do all of this. So this is like the theory of what I've been putting into practice. So I would say start from the foundational courses, certifications. LinkedIn has LinkedIn courses that you can take, a lot of them. In fact, I think there are preparatory courses on the CIPPs, like the CIPTs and the likes. So you can even start from there, like even while taking courses on Coursera, Udemy, Simple Learn, and all of that before you go into the CIPPs. So ISC2 also has like really good certifications that you can take. There's the CGRSC, something in relation to risk. There's the CDPSC from Isaka. There are a lot of them, but as a beginner, as somebody who is just starting out, start with the foundational courses. But one thing I would say is to stay curious, like ask questions. I mean, even the seemingly perfect policies that you see online, they are not perfect. There might be loopholes that you can pick out from there. So yeah.
Thank you so much, Sandra. I really appreciate that answer. And to wrap up part three, that's becoming a specialist. Since the people on this call are mostly lawyers, they already have the foundational necessity, for them to pivot into privacy. So what is left, just in case they don't already have this, would be to learn spreadsheet to help them with the day-to-day runnings of, becoming a data privacy specialist, and then upscaling their knowledge base using like free resources that are already available, such as Udemy, LinkedIn, Coursera, and all of that. That's amazing. Thank you so much for simplifying this, for all of us. Okay, moving on to the next part, which is our part four, getting started and growing your career. I want to start with Sandra because you did mention when you were answering the previous question that you didn't, write the core professional, exams until you had spent some time in the field. So how did you land, your first role or client or, all of that in privacy without any prior experience? I'm personally curious, and I'm sure that lots of people on the call are also very curious about this answer.
So I think it was straight out of, I'd worked 1 year just doing in-house work, law pavilion. Not sure if, yeah, so I'd worked in
Okay.
law pavilion, but then I wanted something challenging. I love challenges. Like I think it wasn't challenging for me. It didn't seem like something that I wanted to spend the rest of my life doing, or like the next 5, 10 years doing. So I think then there was an advert. It was in 2020. had an advert for, there was an essay competition where we needed to kind of like just write an essay on the Nigerian Data Protection Regulation, how far it had come, like accomplishments and all of that. So I looked at it and I was like, okay. I mean, basically that piqued my interest in privacy. I'm like, okay, I think that was the first time I'd even heard about it. That was the first time I was hearing about it. So I'm like, okay, maybe this is something that I can write on. So I remember just researching, doing everything I can, like putting in that particular research work. I didn't win, but I did get the honorary mention. So I think that kind of like it boosted my ego, sort of like, okay, I know this thing, like whatever it was that I thought I knew, then I felt like okay, and it gave me confidence. So my then boss, that was my first privacy boss, reached out and was like, "Oh, is this something that you're interested in? Oh, I did see this. I did see that you wrote this." He was one of the judges for that particular essay competition. So I'm like, "Oh yes, this is something that I'm interested in," and just explain my interest, my curiosity, and that was how I got into Tech Hive. I got into Tech Hive, started with Tech Hive. Like it was just I had basic foundational knowledge. Honestly, when I look back, I'm still very grateful that because you don't have a lot of organizations take chances on you or like allow you just that, allow you to put your feet like into the dirty work and just learn from it. So I think that was what happened to me. Like I had maybe like very few, maybe like one or two courses that I'd taken at the time, and then I dived right in. There were a lot of days I was clueless. There are a lot of things I didn't understand, but I mean, just I had to just keep reading, like, studying, asking questions, being curious. I was also very much involved in the research part of data protection at the time and privacy. So it kind of was eye opening because even long before I moved to Canada, I was already like looking at Canadian laws, like researching them, knowing stuff in different laws in the EU and all, like even knowing sectorial laws in Nigeria. So it kind of opened my eye to a lot of things even before I took the certification. So when I took the certification, a year was exactly a year later. It was just like it was sweet. That's what I would say. Like it was really nice. So yeah, that's what I would say. Like just I mean it's we don't get a lot of opportunity to just have that company take a chance on us and just allow us, oh okay, you don't have the practical knowledge, come work for us. But then like there are lots of things that we can do. Like Anita mentioned, and I mentioned earlier as well, that you can kind of like make yourself have a leverage above the theoretical knowledge that most people in the industry coming up maybe have. Yeah.
Mm, thank you. Well, while you were answering, you did mention that you had done, a research. You put yourself out there, and that was why that opportunity came to you. So you had already taken the first step in that sense, being in that space. So I think you did something before that opportunity sort of found its way.
Yes, absolutely.
Yeah.
Yeah,
Okay,
absolutely.
cool. So, all right, moving on to Anita, you transitioned from litigation to privacy. What helped you make this pivot, and what advice would you give someone who is starting out now?
Okay, so what made me make this decision? The simple, truthful answer is I got bored of litigation. I was going to court almost every day, and I got bored. And I wanted something better. As Sandra said, there's this point in your life where you get to be like, this is not what I want to do for the rest of my life. And I think Sandra and I have a very, very similar story on our journey because same here, I didn't write any of my certifications until like after a year at the job and after being in this. So what even happened was, as I mentioned earlier, there was a case. I handled the litigation that just opened my eyes into data protection. And at the time, that was 2016, 2016, 2017. I was interning. I was interning at Paul Erokoro, and while I was interning, we were doing research for our externship, and I saw it, and I was like, "This is interesting." Funny enough, after I got called and I started working with Paul Erokoro in 2019, I met that case. Of course, we know how Nigerian litigation cases span up to 20 years. And I started handling that case, and I was like, "This is interesting." So I started reading up on it as well, reading about this is 2019, the GDPR was still fresh. And a friend of mine who moved to Estonia was like, "Look, Anita, you mentioned this was interesting. It's something you need to get into." I was like, "Okay," but it was something I started, and then I decided, okay, what do I do to come in there? I think this is where me and Sandra are different. I was like, I needed something. I needed to do my master's. I've always wanted to do my master's, so I said I wanted to do a master's related to privacy, but you don't see a master's in privacy like often. Maybe some things have changed, but I now saw this master's in IT law, and I was like, okay, IT law. Don't let the name scare you. There was nothing IT about it. It was more like data protection and cybersecurity and information technology. I think I only did anything coding for only one semester, and I still have PTSD from it. So yes, but I did mostly IT law, and it was just a 1 year course. It was an intensive 1 year course, so I'll not say just. And once I did that, still didn't have any practical knowledge on it. I had theoretical knowledge. And so, how I landed my first job was I applied. I just applied and I was like, look, the requirement was like at least 2 years in privacy, CIPPE, CIPPM, that and that and that. You should have any of this. And I was like, by faith and strong head, I shall apply. And I applied and I asked my boss, like, why me? I didn't have anything. The only thing I had on that requirement was like, should be a lawyer and speaks English. And they were like, "Oh yeah, we saw your litigation years because they saw the year in my CV that I'd been a litigation lawyer for almost 6 years." And they were like, "If I could do litigation for that long, then data protection would be a walk in the park." And it was a walk in the park because what I had learned in IT law during my program, as Sandra said, it's theoretical. But when you come into practice and DSRs are hitting you and cookies. I mean, what I learned from the e-privacy directive and what I'm seeing now with cookies are not the same thing. DPIAs, PIAs are not the same things. It's just like I think I'll make a practical example. What you learn in law school is totally different from what you do in practice in litigation. Am I correct? I'm correct. Because we all saw that. We learned something, one thing in law school, and the next thing is different. The court rules are different and everything. So theory is always different from practice. So when I joined and I had to practice what I had learned on IT law, it was like, okay, this is totally different. But no, I won't say vastly or totally different, but it was strangely different. But you learn on the job because you have the base foundation. So I'll say you should just try to learn. I did some courses on Coursera as well, Udemy as well, and you learn. As Sandra said, when you're writing the CIPPE, it's a walk in the park because you're like, I would say practical example for me was that the exam lasts 150 minutes and I was done in 45. And I had to sit down there and I was just staring at the a computer because this is something you do every day. They ask you questions, you do. I mean, the CIPP can get tricky because very close, but if you know what you do practically, you'll be able to spot those differences. I can't think of an example now, but I know there was something like that, a very tricky case for me. And I looked at it and I was like, oh, it's something I'd actually come across because as part of compliance from our side, we keep up with, as Sandra said, be curious. We keep up with news updates. What the CJEU is stating. We keep up with what Max Schrems is shaking in the data protection world. We keep up with news. You have to keep up and keep up and keep up. You have to read. I read at least 4 case laws, new case laws that are decided every Thursday. Just maybe not the full case, but excerpt to see, okay, what's the main point, what was decided, what was the fact, just to say, okay, this is what it is. I have that on my calendar. So I think you should get curious. For me, it works with having it on a calendar that, okay, I have to look at this every Thursday, just look at it. There's a site, know before. I will check for the site. It's something that keeps you up. GDPR Today. Yes, that's the name of the site. Just search for gdprtoday.com. You keep up with news. So that way you're like kept abreast. And so when you know this, you get to pass. So it's not so easy, unfortunate, for people to pass the initial stage of being picked. But when you get to an interview stage, once you speak, people would not know that you don't have any practical knowledge on this. So I think you should start somewhere.
Okay, wow, that was very detailed. Thank you very much for that response. So, Sandra, you are into privacy and then you are also into cybersecurity. So, my question to you would be like, can someone actually really combine, privacy law with like cybersecurity and privacy is very close niche, but what if like other specializations, like maybe combine privacy with like fintech or corporate law, IP, especially in a place like Nigeria. What do you think?
Absolutely, absolutely. I was mentioning earlier that we have a lot of fintech companies coming up in Nigeria now, health tech, edutech companies. These are edutech are looking at the educational aspect of tech, like in relation to educational sectors and all of that. So they are collecting personal information. So whatever these texts are being built for, there's personal information being collected by them. I mean, remember during COVID when I think people had to pivot to Google Meet to take classes. I mean, schools had to start using it. So you have to now start looking at what it's being used in the educational sector. So what does that look like? How does privacy come into this fintech sector? Because I mean, financial sector, there's just a lot of personal information that goes into that sector. So if when apps are being built, banks and the likes, they need privacy professionals. Like we cannot even talk about the volume of data that banks and financial sector they collect like all over the world. So like they need privacy professionals. Like they, I don't think there would ever be dearth of privacy professionals like when it comes to these organizations. Also, we're looking at things like, for example, employment law. Employment law kind of allows you to, you are in privacy, but if you marry it with employment law, you are able to better advise on this is how we should treat employee personal information. Because sometimes companies don't get it. Sometimes companies like you are kind of like the one there that has to say, okay, this is because this is employee data, this is how it should be done. Or even in situations like intellectual property, like privacy in relation to intellectual property, or marrying that together. There's a lot of fields, a lot of areas that you can combine with privacy. I mean, I think the most common one of them kind of it seems to be cybersecurity because they're kind of just really closely related and um, I mean, they kind of they tie into each other in a way. So that kind of seems to be the common one. But if you are interested in fintech, like in the financial sector, energy, intellectual property, employment law, you can marry that with privacy. So it's not something that is impossible to do.
Thank you. Thank you very much. So whatever they are doing now, or whatever interest they have, they just need to sort of increase their interest and look into other areas if they want to.
Yes,
Okay.
yes, and one thing that I would like to say is that add to that is that when you combine two fields, it makes you more, should I say, marketable, or should I say employable, in the sense of now I have an interest in AI as well. Because remember, I was mentioning how privacy departments are now kind of like combining AI into their workload and the things that they do. So a lot of times I see job ads like until tomorrow, I see job ads on LinkedIn, and you see that they're telling you they want the job designation says a privacy specialist or says a privacy consultant. But when you look at the ads, you are seeing technical skills that they expect you to have that which if you have a knowledge of cybersecurity, okay, okay, this looks like something that I can do. Or if you have a knowledge of AI, oh, we want somebody like it's something. So it kind of like you don't want to be streamlined to just privacy alone because you might see this job ads and you feel like, oh, I can't apply because I don't know this. Like I don't know, I don't have what they want, right? But then when you start developing this interest in this area and start building up on not just privacy, these other areas, it helps you to be able to see a job and say, okay, I'm qualified, I can apply for this. So if you want to be employable, you need to be looking at privacy in relation to a ton of other areas. Also to be able to put yourself out there to apply for like a lot of roles.
Wow. Thank you. Thank you for that. So, as lawyers, we have the responsibility to know more, sort of, if you want to do better in this field. Amazing. Okay, so I see that we do have some questions here in the chat, but most of them have already been answered. And there is one question about what to look out for in a DSAR. Anita, maybe you want to answer this question. What are the primary things to look out for, like when you're looking at a DPA or a DSA? That's one question we have.
Okay, what are you looking at? First, you need to understand the relationship for that DSA or the DPA. Are you the controller? Are you the processor? So is it a DSA or DPA for controller-controller relationship or controller-processor relationship? What are you acting as? That's the first thing you need to know, because there are responsibilities that are different. If you go to Article 28 of the GDPR, it outlines the responsibility of a processor. Specifically for the processor, the rest of the GDPR is for controllers, but specifically for processors, you need to see that. So you need to understand, what am I in this relationship? Am I the processor or am I the controller? Usually it's a controller that actually drafts the DPA or DSA. So you understand. And then there's a relationship where you guys are independent controllers. So everybody's having their responsibility as controllers. That is the simplest DPA to draft. You'll be like, okay, in this DPA, we are both controllers, independent controllers. So we handle our relationship as independent controllers, and we handle all our liabilities and responsibilities under the law as independent controllers. You just owe each other communication that, okay, if we are going to do this, we communicate. If there is this, we communicate. That's it, communication. But if you're looking at a controller-processor relationship, now that is what is different, because now you're looking at you have to ensure that the processor is acting only on your instructions. Because if they act outside your instructions, they become controllers by themselves in that aspect. So you have to state it there clearly that the controller or the processor would act under the instructions of the controller. You're going to process the data the way I asked you, because if you look at the definition of controller, who is a controller? It's the person that determines the means and purpose of processing. So you're going to process my data this way. You're going to use this to process it. You're going to process it at this time frame. At the end of the day, once you're done processing, you either delete or return all the data you used to process at the end of our relationship. We do audits. We do that, okay, in case of data breach, you are supposed to inform me immediately so that we can do our own, because under the GDPR, when it's a material breach that you have not sorted, within 72 hours, you need to alert the supervisory authority, because in the EU, every country has a supervisory authority. So imagine if a processor has a data breach and they don't inform us. We'll be held responsible because we were supposed to do our due diligence. That is why you have to look at. So you have to, the most important thing, you've seen how you draft your contract, because you know that under contract law, the court doesn't hear they say. There's only few cases where the court implies, but it's what's on the paper that the court will look at. It's just like any other contract. Whatever you need to be enforceable needs to be stated in the DPA. So you're looking at audit, you're looking at responsibility, you're looking at breach notification, you're looking at data deletion and return. Usually how we say it is, there's a template. You have to return or delete all data within 30 days after the termination of this relationship, or well, usually 30 days. You have to see that, okay, what happens, who bears liability where there's a data breach. These are the things you need to see. So like every other contract, first and foremost, you have to state it out there. What are we? It's a relationship, so what are we? Define it. And then you have to now decide that, okay, these are the responsibilities, these are my instructions. And as a controller, you need to state your instructions clearly. This is what you're going to do with this data. And you have to itemize it. If you're giving them, okay, name, email addresses and this, you have to state, what are you using the name for? Should they use the name for? Let's say, for instance, employees on a payroll. You're using another, maybe a payment provider to pay your employees. You have to state that you're only going to process my employees' data for the purpose of payment. Any other thing aside from that, you bear responsibility and you're a controller. So where there's a data breach or there's any case for data subject request, you would answer it. Who answers the data subject request? Is it the processor or the controller? These things are stated in the DPA or DSA. Well, the DSA is usually, from our side here in the EU, we use the DSA when they're like, maybe there's a subsidiary and the parent company. So we're sharing within the organization, but we use a DPA for external vendors. So, but it's basically the same. Just to state that these are the things we are going to do, what is going to guide this relationship. And of course, as I said, online templates everywhere you would see.
Okay, thank you very much. I'm sure with this very detailed answer, the person who asked this question, it should be satisfied. Okay, so I have one more question before I move on to the next part, which we should be done now, but it's so interesting and we just kept going. So, so I have one more question and then we would try to finish up. Okay, so the question is actually for both of you, Anita and Sandra. I would like to hear from both perspectives. What 3 actions would you recommend anyone here today to take immediately after this webinar to begin their privacy law journey? What are the 3 actions that you would advise that they take?
Okay, since my mic is on. First
Yeah.
things first, go and read. Go and read. First things first, go and read. You need to be curious. Okay, we have mentioned GDPR. Go and find what the GDPR is. You have mentioned the e-privacy directive. Go and find it. I've mentioned Max Schrems case. Go and find it. Because if you do not look for it and let it pique your interest, this will just be like another webinar. So that's the first thing. Go and read and get yourself curious. 2, you can, once you've gotten yourself curious, go to those Coursera courses and Udemy courses and start. Some of them, most of them are free. They are very short, but they are free. They give you the basic things you need to do. When I mean read the GDPR as well. GDPR is about 80 something pages. Read it like you're reading a storybook and you'll be fine. Then, once you're done with those courses, try to like maybe, I don't know if anybody's working in your organization. Ask questions. What are you doing with my data? It might sound very crazy because I know a friend that actually started this, and this is a true life story. When he found out that I did this and we had this conversation, he started asking his company, you know what are we doing with my data? And now, because of this question, they actually put him in charge of privacy at his office. It's a true life story. At his office, they're like, okay, he should handle data protection and privacy. And then when they're dealing with other vendors to, okay, handle it, ensure that we're in compliance. Because in Nigeria right now, people do not understand that there are fines. I think I saw 55 million, up to 55 million naira fine, or 550 million fine, something like that. There are fines attached to this. Now, people would go on to say, oh, it's Nigeria, no enforcement. You'll be surprised that they are enforcing it. I think they have enforced about 2 as of the last time I checked. So you can start having a conversation at your office, like, oh, this is data protection. Are you interested? This is what it is. Ask questions about what's happening with your data. How are you processing my data? Where are you keeping my names and everything? Because I know people still use file cabinets, even a file. Look, processing is defined as a structured keeping of personal data. It could be online or offline. So if you have a structured filing system, so if you're putting people's files in a drawer, you're processing data. So it doesn't have to be online. You're processing data by just putting people's files, somebody's name in a drawer. So talk to your employers and start there. So read, number 1, get the courses, number 2, start conversations, number 3.
Mhm. Thank you very, very much, Anita. Moving on to Sandra, what are the 3 things you would advise?
So just building up on what Anita said, read, take courses, start conversations, just stay curious, build visibility as well. Visibility in the sense of you have LinkedIn, like there's so many privacy professionals, people that are willing to help. I remembered when I wrote that essay, the research work I did for lawyers, that kind of like just puts me out there for my first role. I reached out to a prominent privacy figure in Nigeria, Olumide Babalola, and he was so gracious. Like he answered all of the many questions that I had. It was just via LinkedIn. Oh, I have this question. I'm writing this research work. What do you think? Like, what is so? Reach out to people, build visibility. So, like Anita said, when you read, when you take these courses, what are your thoughts? What are your opinion? What do you think? Put them up on LinkedIn. Ask people to share. Let people comment. Let people kind of like also engage with what you've studied, what you've read. It might seem like, oh, I mean, they already know all of this, but people know you are just starting out. I mean, so they want to be able to provide guidance, they want to be able to help you. So it kind of just, it also builds your confidence, helps you know that, okay, I'm on the right track. I mean, what feedback are you getting? You can build up on it, just like make yourself better. They get better understanding as well. So that's one thing I would say. build visibility on LinkedIn, make posts, like, share comments, engage with people. It doesn't have to be on LinkedIn. It can be via DMs. Oh, I see the work you are doing in privacy. I have this question. What do you think? Right? It can also be in person. If you know someone, maybe in your organization or elsewhere, and they are like an expert in the field, or they're already like a professional in the field, you can also ask them questions like, what do they think about this? Also, I would say, um subscribe to newsletters. IAPP has all of these. I think maybe digest or something that you can subscribe to. I can't remember what the name is. I only just subscribed to them myself because I was going through my profile one day and I realized, oh, I'd like to know what's happening in the EU, in Canada, in this area. Okay, start sending me this news, and I get them in my email. So things like that are things that you can do to kind of stay informed, to stay curious. Anita mentioned you have to read, like you actually have to read. There are a lot of things, like it's kind of like a rabbit hole. Like you keep reading, it leads you into like other areas. There are different areas of privacy. There's telecoms, there's education, there's workplace privacy. There's a host of knowledge that you can get from just reading. So that's what I would say. And then deep learning as well. I mentioned that earlier, that when you are studying, like study deeply, understand the why, you would see the laws, what the laws have said. Yeah, that is like clearly evident, right? But then, like, how does this work in practice? That's something that you also have to kind of like look at. I feel like those are the things that you should work on. Reach out to people in the DMs, physically, on LinkedIn, engage, take courses. Yeah.
Wow. Thank you so much. Thank you to Anita and to Sandra. This was very insightful, like so many pointers. I feel like even the people watching the webinar have like assignments from the webinar. Now they can actually, figure out how to start a career in privacy. So thank you so much to both of you. Okay, we're moving on to the last part now, which is practically just, a wrap up and takeaway. So at the end of this webinar, we would be sending to your inbox a toolkit which would practically, have most of what Anita and Sandra have said in this webinar. Some points that will help you to start out as a privacy lawyer. Follow us also on all of our social media accounts. Please reach out to Anita or Sandra if you need anything related to privacy in the future. I'm very sure that they would be very happy to assist you. We do have subsequent webinars that will be coming up in other areas. So to keep abreast of all of this, please try to follow us on all of our social medias and also check out our website. Also look at our blogs if you're looking at places, or you want to read more about privacy or any of the other areas that we will be talking about in our subsequent webinars. Look at Njunkim Legal blogs also. For mentorship, there is a WhatsApp group. You would be receiving a link in your inbox after this webinar. You have to click to join because, again, your consent is definitely very much needed. After this webinar, you have to consciously decide that you want to join that WhatsApp group for you to join the WhatsApp group. Thank you all very much. Thank you, Anita. Thank you, Sandra. And I think we would call it a day here.
Thank you so much.
Thank you. Okay, bye now. Bye, everyone.
Bye.